I'll start by introducing myself, and then I'll pass it on to John quickly. Steve Saville. I'm a partner in our securities group at Faskins. I started off in our Toronto office back in 2004, worked there for a couple of years, mainly in public markets type practice. Worked in London, England for 2 years doing emerging market work there, a lot of work from India and Singapore, and sort of Eastern Europe. And then I've been in the Vancouver office of Faskins since 2008. When I moved here, I was doing a lot of public company work, but over the 8 years, I've gradually moved from public company to probably about 60% private company startup type work and still public company. So it's a skill set that allows you to start from the incorporation and also work on the IPO if that's the way it goes. And yeah, that's pretty much my background. I'll pass it on to John for his.
Thanks, Steve. My name is John Conlin. I've been at Faskins going on my 7th year now. Spent the bulk of my practice doing startup work, so taking companies through their entire life cycle, speaking to entrepreneurs like you guys, but then also helping them grow their business, whether that means encountering issues with financing and the corporate finance side, also helping them with issues of governance, dealing with their boards, their other officers, employees, things like that, dealing with their commercial partners, and hopefully dealing with their eventual purchaser or help them as they acquire other businesses to grow. So I find it to be a really rewarding practice to be a very small part of helping people like you be successful, and it's just a really rewarding practice to be surrounded by so many creative people and watch as they turn their crazy ideas into a real business that makes money.
Let's go to... All right, so just quickly again about our firm. We are a national and international law firm. We've got offices in Vancouver, Calgary, Toronto, Ottawa, Montreal, Quebec City, London, England, and Johannesburg. And we're what you call a full service firm. So we can do your startup work, we can do your real estate, we can do employment law, litigation, tax, estate planning, you name it. It's we offer the full suite of services. So I think that's, we certainly see as a competitive advantage, a client being able to come in and be a one-stop shop. And with the international presence and the national presence, we can service needs all the way across the country and in lots of other countries as well. I'll let John talk about the tech group specifically.
Yeah, so we're pretty proud of what we've grown in our emerging companies group. We've got about 12 full-time people working there, along with patent trademark agents, and really it's a result of the firm making an investment in this industry 20 years ago, 25 years ago, before experiencing the popularity and the growth that it is now. We always make the joke that a lot of lawyers are now either tech lawyers or they're working for marijuana companies. So we're not new to the game, and so it's a pretty exciting group to be in. But we'll stop talking about ourselves.
All right. This one's here.
So at a very high level, one of the key things we're going to talk about is how to set up your corporate structure. So how and where to set up your company. How do you determine how the ownership of that company is established, maintained, how disputes are handled, attracting and retaining team members, whether that be employees, whether that be shareholders, whether that be commercial partners, things like that, and attracting and closing financing, something that's likely on the top of many of your minds, just as the reality of starting an enterprise. You need capital to do that. Getting into more specifics, we'll talk about legal agreements. This is really documenting the foundation development of your venture. And we'll go through this very quickly, so very much appreciate that you will have questions and look forward to answering them. When we're talking about agreements, we're talking about things internal to your business, shareholders agreement, how you and your other shareholders deal with the ownership and the rights attached to the shares, the evidence of your equity ownership of the company, and what rights you have with respect to certain activities, certain management and governance issues, IP assignment agreements, making sure that your company owns all of the intellectual property that it needs to grow this business and that investors will expect it owns, so they know that they're investing in the entity that has all of this, the secret sauce in it. Consulting agreements, employment agreements, making sure that you have very tight agreements and clear understanding with your personnel about what they're doing, the fact that the company owns what they're creating on behalf of the company, making sure that in the event that, as it so often does, that sometimes things don't work out, that there's a very clear way for the company and that person to end their relationship. And things like reverse vesting agreements, making sure that when you and your co-founders start this company, you'll likely say, you'll likely draw on a board, I get 50%, Steve gets 50%. Well, that's based on an understanding many times not what's been done in the past, but what you expect to be done in the future. You're looking at each other and what began as a handshake saying, we're both going to throw everything at this. An agreement like a reverse vest agreement says, well, in the event that Steve wins the lottery or decides that he wants to go sail a boat around the Caribbean, there's an opportunity for us to recalibrate that initial understanding of who owned what. Then there's external documents, term sheets, and other documents with respect to financings, making sure that you're engaging the angel community, the venture capital community, in a very clear way that shows that you're a sophisticated party that understands what's involved in getting money into your company, and non-disclosure agreements, whether it's with those investors as they kind of look under the hood and see what makes you special. You want to make sure that you're protected, because oftentimes, as many of you know, all you have right now is an idea, and you want to protect that with all the tools you have possible. And then NDAs also with commercial partners, thinking of establishing a relationship with a strategic partner and making sure that you're protected on the commercial side as well. And same thing with license agreements, other commercial agreements. We won't get too much into those, as that's kind of the next step from our talk, but certainly something to note.
All right. So options for setting yourself up. Proprietorship, a sole proprietorship is almost never a good idea. You are 100% liable for the debts of the business or for any mishaps in the business. It's you taking the personal liability. It's not a structure you can finance into, other than people just giving you personal loans that you guarantee that you can't give anybody an equity interest in sole proprietorship. So very rarely a good idea. Partnerships, also very rarely a good idea for a startup. In this case, both the partners are 100% liable for the debts of the organization. You don't have limited liability in a partnership. So cross that off your list if you're wanting to set up a company that people are going to invest in. People wouldn't want to invest into a partnership where somebody else was making the decisions and they were liable. Limited partnerships are slightly better. In limited partnerships, you have a corporation take on the liability structure and the partners can invest but not be liable. They're typically good for businesses where you're just flowing income up to people. If you had a royalty business or something like that, you're not actually doing active business operations within the structure. You can just flow income out to the partners and they just pay their own tax rate for it rather than paying corporate tax. But if you're setting up a business that's going to grow, you want to set up a company, because that's the one where you put the money in and it grows within the company, and it gives you the limited liability and all the other things that you want in order to get your vehicle going. So companies, certainly for active businesses, are almost always the way to go. If somebody tells you a limited partnership, it's normally because there's a specific aspect of the business that makes sense to do it, where it's a real estate investment and you just bought the property and you're not actually running a business. But for businesses, corporations are the way to go. And then joint ventures, I've got that on the slide. That's just basically two corporations typically agreeing to work together on an opportunity, and that sort of you can set up a structure around that particular opportunity.
Yeah, we include this slide to be comprehensive, but the one takeaway, the one note you should be writing is, it'll be a corporation.
Yeah.
There's simply no business reason to create some sort of complex business organization. It's just not.
Yeah. So we're going to be talking about corporations on the go forward. So corporations, and you can see on the slide, you've got your shareholders at the top. They provide the money. They have no liability. They have certain rights and restrictions, or certain rights that both at law in terms of voting for the board of directors. And then also, if you're going with outside investors, they're going to want a shareholders agreement that gives them some additional rights, that maybe to approve the budget of the company, different things. But shareholders are a step removed from management. They're the ones that sort of sit outside the box. They have the beneficial interest in the product, or in the value of the company, but they're not the ones that are taking on risk or conducting day-to-day operations typically. Then the shareholders elect the board of directors. Every company needs, you don't need a board of directors, but every company needs at least one director. Directors are always individuals. Sometimes people will come, oh, we want this corporation to be the director of the company. It doesn't work that way. It has to be a person. So, and officers is the next level down, and those aren't required. Most companies typically have officers, but the minimum requirement for having a corporation in Canada is you need one director and one shareholder. So that's sort of how the box works. It's shareholders, they elect directors. Directors are responsible for supervising the management of the company, and they've got fiduciary duties to the shareholders and to the corporation. And then the directors hire the officers, and below that, the officers typically would hire the other employees. So that's how the hierarchy works. Sometimes you hear about people having an advisory, they often use the word advisory board. Typically, that's not the board of the directors of the company. It's just a group of consultants that provide sort of guidance, typically at the compensation of stock options. But it normally needs to be distinguished with the actual board of directors, who are directors of the company, have fiduciary duties to the company, and have obligations under the statute. So shareholders, as I mentioned before, directors need to be individuals. Shareholders can be effectively anything. It's individuals, companies. You just take them as you find them. So somebody says, this is the name of my shareholder. It's this person. It's this partnership. Doesn't really matter. You can have as many as you want. Very important to know in Canada, the rules change when you cross over from 50 shareholders. So if you're under 50 shareholders, you're sort of within one set of rules where there's less disclosure of fundraising to the securities commissions. There's a number of sort of exemptions for transactions, like takeover bids or issuer bids, things like that, that when you're under 50 shareholders, they sort of put you in one category where you can do a lot of things without seeking further approvals. When you move above 50 shareholders, you're filing reports with the Securities Commission when you do financing. You don't have some of the typical exemptions for takeover bids, and you have to go through a more formal process. So over 50 shareholders doesn't make you a public company, but it does take you out of the private company. And it's just you're no longer a private issuer, which has some benefits under securities law. So if it was the difference between 49 and 50 shareholders, I'd keep it at 49 for a while. If it's worth it to go over 50 because the check's the right size or the opportunity's right, go for it. But just be aware that there is a consequence to going over that 50 shareholder limit, and it's an administrative consequence. There'll just be more work, more compliance, that sort of thing. So next slide, shareholders, no liability. Nobody's going to want to invest in the company and not run the company unless they've got limited liability, because why would you give money past management over to somebody else and be liable for their decisions? And with corporations, there's a lot of kind of cool things that you can do that you can't do in any other in a lot of other structures. So you can really slice and dice the vote, the share structure, voting, non-voting. People having preferred rights, dividending to different classes. There's a lot of bells and whistles. The best thing to do is keep it simple, quite frankly. Have a class of common shares for everybody. When you get your A round, your first significant investors, you can expect them to want to have sort of a class A with certain special rights and restrictions, but keep it as simple as possible. Let me see. So if we just go to the next slide. Shareholders, so they have the right to elect the board. What when you work for a minority shareholder, you normally want a number of rights within an agreement. If they're putting a check in, yes, they get the right to elect the board, but a very important thing for a shareholder coming in is preemptive rights. And this is how you don't get diluted. So if I wrote a check to you guys, or one of you, for $10,000 at $1 a share, that's all great. If you turn around and a week later and issue somebody 1 million shares at 10 cents, then my investment's just gone up in smoke, right? It's been completely diluted. So if you're coming in as a minority participant, you want to have preemptive rights. So if they do that share issuance at a dilutive thing, you get the right to participate and keep your pro rata share of those penny shares and not go down. So don't forget about that one. Make sure if you're investing and that you're going to get preemptive rights and you want those in a shareholders agreement. The other thing from the company's side is you never want to issue shares without a way to get them back if you have to. So the worst thing you can do is be in a situation where so-and-so, Microsoft came and wanted to buy my company. Everybody wants it, but we've got this one shareholder that doesn't like it, and he's holding up the deal, and he won't sell his shares, and he thinks they're undervalued, but he doesn't know what's going on. So anytime you have minority shareholders, put in agreements so you can deal with them. You have, in a shareholder agreement or voting trust, you have drag-along rights. Very typical, very important. If 50% or 60% or whatever it is want to sell their shares, they can pull everybody else along with them. And very, very important. If you have stock options that you're granting out, those can be even worse because that's just a contract. And if you granted somebody a stock option and Microsoft comes and wants to buy your company, they're not going to want to buy a company that has, somebody can exercise a stock option 2 years later when they think they're owning 100%. So in the stock options, you need to put in something that accelerates them on a change of control. If they're going to exercise, they've got 5 days notice. You exercise or they're done. So always, every time you're issuing a security or a right to security, you got to think about how you're going to call it back if you have to, or how you're going to force them into the deal that you're going to want to do. So warrant certificates, same thing. Need to have something in there that has a way to deal with them. So issuing stock is great, but never do it without thinking about how you're going to get it back if you have to. And repurchase rights in certain circumstances. If it's an employee, if they leave, it's a repurchase right in your stock option or in your shareholder agreement. Stock options terminate on, if somebody leaves. You've got to deal with all those sorts of particulars every time you issue shares, or else you could be in a situation where, and we see it, normally after the fact, where it's, we've got this great thing. We've got these 2 disgruntled shareholders. They're holding everything up. How are we going to deal with them? And you basically have to negotiate with them. And how fun is it negotiating with somebody that has leverage? So be careful. Make sure you're thinking about who you're giving it to and how you're going to get it back if you need to.
Yeah, so just a couple things to say at this point. First of all, if I was in your shoes, I'd be thinking, this is a lot. And I'm not going to remember to tell my lawyer all this. The good news is that there is a very established bar in this city. It's not just us. There's a lot of other practitioners that we work with every day. A lawyer that practices in this area and focuses on it is going to be able to present you with a relatively standard set of paper that protects you in all these things we're talking about and that we will talk about. And the second thing I'd note is that a theme you're going to notice is when, if you were to kind of put it on, control versus money. The earlier stage money is going to allow you to have more control, and they're going to accept a higher downside. The more sophisticated and the more mature money that comes in, to use very simple concepts, is going to protect their downside, and we'll talk about that. And they're going to start establishing negative, they're going to start veto rights. So they're going to say, hey, you're the crazy entrepreneur. You know this, so I'm not going to tell you how to, develop your IP. But what I will do is I will block you if you. I have a blocking right if you try to borrow $10 million from the bank. I have a blocking right if you try to move this company, to another jurisdiction where I don't like it. I have a blocking right if you try to do X, Y, or Z. So one of the things you'll pick up on as we're talking is that as you engage with more and more sophisticated investors, they will start protecting their downside and start blocking certain decisions, and a lot of that is common sense. And then as you grow even further, then investors will start establishing certain upsides and things like that. And all you need to do once you start to get a little bit of a handle on these concepts is start reading some of the tech news, especially out of the Valley. So much of our industry is informed by new market terms that are established down there. Is seeing how those are expressed when there's an exit. Company sells for $500 million, but there was some huge right that somebody had to a 2x, 3x return on their money. They scooped up so much of that, so the founders only got left with much less than you'd think when they sold their company for $500 million. So there's a lot drinking from the fire hose right now, but we know it's a lot, and this is just the first conversation of hopefully many for you guys.
All right, so that was shareholders. We'll just talk about directors here. So directors, and I'll probably need to speed up a bit here. So directors are elected by shareholders. The requirement is that you have one. You can have, theoretically as many as you want. You don't want to have an unmanageable number of directors, so you don't sort of give this position away to everybody, because you need directors to approve things, and you can normally approve by a majority, but the process of calling meetings for numbers of people isn't good. So 2, 3, 4, 5 directors is where you want to be. For BC companies, there's no residency requirement. That's one of the reasons a lot of international mining companies and different things are headquartered or incorporated under BC law, because you could have one Australian, one English, one South African is the board of directors, whereas in the federal statute and most of the other provinces, you need to have either a quarter of the directors or a third of the directors are Canadian residents. So good corporate law in BC for that, because it gives you flexibility. Qualifications, they're not too hard to meet. You've got to be 18, of sound mind, and no insolvency, I think. Anyway, it's for most people that you want to do business with, those ones they should be easy to meet.
Some criminal code violations.
Yeah. So the director's role, they manage the affairs of the company, so that the CEO and the officers report to the board. The board sets policy, the officers carry out the policy, so it's a governance role. They've got fiduciary duties, so it's duty to act fairly and diligently in the best interest of the company, duty of care. You've got to be duly diligent in carrying out the role. There is potential liability for directors, so I sometimes, I have some clients that are always fighting to be on the board, and I sometimes think, are you sure you want to do that? Because if a company goes downhill, you can be on the hook for wages to employees and unpaid taxes. So that's why if somebody wants you to be on the board, you should ask about the D&O insurance policy. Because I would always require that. Other than like a family company or something like that. But any company that's active, think about D&O insurance, because it is. Those roles do have personal liability, so it's not all gravy being on the board. The directors appoint officers, as we said, so that's how that looks. Officers, the typical roles: president, chairman, CEO, CEO. You can have as many as you want. Again, it's good to have a manageable number. It's good to have a hierarchy. Normally a chief executive officer, financial person, maybe a COO, and that's probably all you need. They run the affairs of the company and report to the board. So employees, it's somewhat a master-servant relationship is what is prescribed in the legal or in the statute. You can have indefinite or fixed-term agreements. There's statutory obligations for severance and for hours and overtime and that sort of thing. A couple of things to be very conscious of is in the technology world, people have personal rights to intellectual property that's created, even if it's created while they're at work. So every technology company in your employment agreements have an assignment of IP, assignment of moral rights. If you miss out on this, and we've dealt with companies where they're on an exit, and again, the Microsoft or whoever coming in and saying, where's your agreements with all your employees that shows that they've assigned their rights in the IP? How are we going to be comfortable that you truly own it when they haven't assigned it? So make sure all your employment agreements with the employees, they're assigning all the rights to the IP they created to the company, and it's going to help you a lot down the road. If you don't do that, there's always going to be a doubt. You want confidentiality obligations in the employment agreement. You want a non-compete. The thing with non-competes you got to be aware of, the shorter the time period that you 6 months or whatever, the shorter the time period, the more likely it's going to be enforceable. So if you like, oh, we've got a non-comp and it's going to be 10 years, so we never have to worry about the guy. The courts will never enforce that. If you've got to have it, it's got to be prescribed in terms of time and location. If your business is in BC, maybe you can get away with 1 year, can't compete in BC. If it's anywhere in the world and it's a long period of time, forget it. So, what I guess, don't overreach on those. Don't overreach. Make sure it's got to be tied into the business. So if you're like, okay, well, we're in BC and we're in Washington State, and that's kind of where we are at, put it in there. Don't overreach, or else you've pretty much blown up the agreement. Non-solicitation, again, you don't want people exiting and then going after your customers. Put something in there about that. Just don't forget about these things. You can also contract for sort of severance entitlements. You can't contract below the minimum, and the Employment Standards Act prescribes a minimum, and you can't contract below that. But if you don't have anything in there, and they went to court, the court may not give them the minimum. They may give them much more than the minimum because they said they've contributed so much, or they've this role is so important or whatnot. So if you put in the contract, you're going to have certainty. Put in the contract, we agree that on termination you'll have severance in accordance with the Employment Standards Act. You've locked it in. If you don't do that, you're rolling the dice if it did go to court, because it's subject to the court's discretion of what's appropriate. Consultants. So we've got a lot of people that they've never hired an employee in their life. All they hire is consultants, and they are in fact hiring employees because it's sort of a substance over form type thing. A lot of people want to call themselves consultants, and they perform services through a company. A bona fide consultant, where they're working for you and they're working for other people. That it's not an exclusive relationship. They use their own tools, things, their own computer, whatnot. Fine, but if it's somebody that they work for you 100% of the time, they sit in your office, you can call them a consultant, but they're truly an employee. They'll be deemed to be an employee, if they leave, and you're dealing with the court in terms of what the severance is. And when they're a consultant, they're required to do their own withholdings for taxes. But if they don't do it, and the true nature of the relationship is employment, the CRA is going to point to you after if they don't do it. So just be wary of it. A lot of people, they think, oh, everybody's consultants. It's a substance over form, and just be wary. If you don't think it's going to work, if you think they are truly employees, I would try to push them in the direction of being employees, or just know that you're subject to the risk that if they're reassigned, redesignated by the CRA, you could be, and they aren't able to pay their withholdings, the finger will get pointed to you to make up the difference. Consulting agreements will have the same things: confidentiality, assignment of IP, non-comp, non-solicitation. Don't miss any of those things. You got to make sure if you're wanting to hang on to the IP and hang on to the customers and the business, you've got all those things in it.
In a consulting agreement or in a consulting relationship, there's less of a presumption that what you're doing for the company is the company's to own. So be extra mindful of those concepts when you're dealing with a consultant.
Yeah, it just in terms of if the IP they're creating, well, if they're a consultant, did they create it for themselves, and should they be licensing it to you? And if they're effectively an employee, you think they're working for you and doing it, but make sure that the agreement says that all that stuff that they're creating for you is your IP, and as opposed to being silent on that. And I talked about the redesignation. Compensation, cash, shares, options. Again, if you're granting them shares or options, you've got to figure out a way to get it back if you have to. If they quit, repurchase options of the shares. If they quit, options, immediately vest and they've got 5 days to exercise, or things like that. You don't want things hanging out long after they're gone, because unless you're happy for them to be shareholders. If you are, fine. But normally when somebody's gone, that you want to be able to find a way to scoop that stuff back, and subject to paying them fair value for it. Advisory panel, there's no real rules here. Just they're not directors, they're not employees. If they're getting confidential information, make sure they still sign a CA, and make sure that, if you're giving them options, just make sure you've got a way to get them back if you have to.
So you're probably saying, well, where is that the right fit, this advisory panel? Think of the the industry expert that's willing to give you 2 hours a quarter, and you want to incentivize them to be, have some sort of skin in the game with your success. These are people that simply, likely can't give you enough time to be more actively involved, whether they're whether they're on your board, and certainly not as an officer of your company. But where we see advisory panels work is it's those people, those experts, usually very senior women and men in your industry, that are willing to give you a lunch every month or something, and you're trying to reward them and make sure that relationship is established in a more formal way. That's really where you want that.
All right. And then other issues. So conflict of interest, just people wear lots of different hats at companies relative to other relationships that they may have. They may be a shareholder and a director that has different interests. They may have be a director of your company and suggesting that you contract with a company that they're brothers with, or where they also have an interest. Be very conscious of conflicts. If you are in the middle of one, make sure it's disclosed. Particularly if you're a director, if you don't disclose a conflict and you vote on something, you can be personally liable for for any sort of loss to the company. So be aware of them, disclose them, and when you realize that you're on the other side of the fence, sometimes it's getting independent legal advice, where my role over here is at odds with the company's role. I'm not going to have one person advise both of us, because it's you need to have each person have their own perspective vetted. So be aware of them, disclose them, don't be silent, and carry through with something. I think that's over to Mr. Conlin here.
Yeah. So initial corporate structuring. Comparing where you would set up your company, it comes no surprise that our recommendation is strongly going to be this jurisdiction, but there's very material reasons for that. You're likely going to be engaging with investors in this jurisdiction that are used to that. A BC or a federal company. We're very lucky in Canada to have a really user-friendly corporate statute, and a very I would say investor-friendly regime in this market, and so one of the things I always say in these talks is let your business, let your idea be the thing that hooks in your investors, hooks in co-founders to do it with you. Really, so it's almost when we as lawyers hear that you guys are willing to take our advice and do it in a very straightforward, boring manner, that's good for us, because we know that that formula works, and we won't have to worry about well, my brother's an accountant and he said we should incorporate in Bermuda, and then we're going to do this thing and that thing. It's no, just do it simply. Okay. The other material reason is because we're very beneficial. We benefit here in Canada with a lot of the government grants, a lot of the non-dilutive funding that we get. I believe there's another full session on this. Some of that is the tail that wags the dog. We have whole financings that are done exclusively around tax, the eligible business tax credit, the VCC tax credit, the 30% refundable tax credit that I'm sure many of you have heard of. And you've obviously heard of IRAP, SHRED, things like that. And a lot of that is that facilitates a lot of the activity in our market, and rightfully so. Taxation and employment issues. much more simple if you're building a company here. Again, whether it's a regime where employment law is kind of a common, I would argue, is relatively common sense based approach, and our taxation regime is when you're comparing against the world is relatively competitive. As Steve mentioned, there are some differences between BC and federal companies. I would say that either is fine. If you're taking my advice, then you're incorporating a BC company for some of the reasons Steve mentioned. But certainly both are fine.
Just one quick thing on this. We've sometimes heard, so-and-so, I'm going to set up a Delaware corporation and this sort of thing. So if you have U.S. investors that insist on that, fair enough. But a BC corporation, you're going to have the benefit of all this, incentivized tax credit structure, SR&ED, Venture Capital Act stuff. None of that's possible if you're a Delaware corporation. So you've kicked out all the tax credit stuff that you'd otherwise have. The other thing is your Canadian shareholders have tons of benefits when they're holding a Canadian corporation. So most people that invest in a company, one of the things they would love to use on exit is what's called the lifetime capital gains exemption. It's available for shares of a Canadian-controlled private corporation. So if you're Delaware Corp, none of them are going to be able to use that lifetime capital gains exemption. So, there's a lot of benefit to being a Canadian-controlled private corporation. Tax credits, stock option, tax treatment on exit. So you're giving up all that stuff, and again, there could be good reason. If you're in Silicon Valley and somebody's going to throw $30 million at you, you say, well, that was worth it. But don't do it, unless you've got that big investor check or that access to the capital down there. You're going to throw away a lot of good stuff if you're not a BC company.
Yeah, so now we know that we're recommending we incorporate, let's call it a BC company. So more specifically, what is the structure within that company? What we would typically see is one class of common shares, an unlimited number that's authorized, and a common share is the most simple evidence of equity ownership. You might hear somebody say, well, I was talking to my friend, and he said that we should have classes A through Z with a whole bunch of different rights. That might work when you own a chain of restaurants, because that chain of restaurants is going to be paying you or is going to create a lot of money that you can distribute out to your shareholders, and maybe those classes you can sprinkle across them various payments to all sorts of people. That's not what we're doing here. So we would recommend a simple one class of common shares, unlimited number of blank check preferred shares. What that is knowing that you're going to go out into the market and get investment, knowing that those investors are likely going to request shares that have certain protections, as we touched on at the beginning. That reference is to establishing from the outset a placeholder class of shares where later you, as maybe the sole director, or you as your three founders, decide to create a series within that class of shares with all the rights that investor is asking for. Obviously, we can't look into our crystal ball and know through the course of that negotiation what that'll be, but that's kind of the setting up a placeholder for that.
Yeah, it's going to shareholders once for the approval, and then the directors just doing it themselves thereafter. So that's the goal of those.
Yeah, and your investors will largely dictate your financing terms. Thankfully, the investors in this market, a lot of the prolific angel investors, they like to do things that are kind of cookie cutter. So it'll be very similar terms to the other 10 investments they did that year, and it could be debt versus equity, whether they're going to loan you money or whether they're going to subscribe for shares of your company, those common shares we talked about. Whether what the price will be. One of the things you guys will all grapple with is somebody's going to say, perfect, I'm going to give you $100,000, and they're going to say, well, what does that get me? What is the price per share? Does that get me? And you say, well, it's going to get you 10% of the company. And you say, okay, well, what I'm hearing is maybe that you're valuing the company at about $1 million or something like that. And they say, well, how do you come up with that? And you say, well, I don't know. It sounded right. No. And sometimes there's a layer of art to this, because how do you value an idea? certainly as lawyers, I'm always interested to see how people come up with the answers to that question. If you can avoid issuing secured debt, it'll limit or make more challenging some of the investment decisions you could make in the future with convertible debt, things like that. Shareholder loans. You may often find yourself bootstrapping, and many of you probably may already be bootstrapping your companies right now. Shareholder loans, to the extent that you can avoid them, investors will often make you convert that loan into shares, usually at the fair market value that you're telling them your company is worth anyways. So that's an investor-friendly, founder-unfriendly outcome for that money that you invested. Sometimes if you have leverage in negotiations, you can establish some sort of repayment scheme, but that's very rare. Multiple classes of shares, as we talked about, incorporating offshore, as we talked about. So again, the takeaway is simplicity, simplicity, simplicity. And again, as an aside, as a practical result of that, you're going to be paying your lawyers and accountants less. And you guys have a very limited amount of capital at this stage. Founder shares. What are founder shares? Founder shares is a colloquial reference to those common shares that we talked about. There isn't a difference between, I'm not going to give them, this. I'm going to give them, I have the founder shares and a different class of common shares. It's probably not the way you should be thinking about it. Founder shares is just a reference to those initial shares that you and your founders are issuing to yourselves at the outset. It's likely going to be for nominal value, so you'll usually see a lawyer tell you that you should issue them for 100th of a cent, 1,000th of a cent. And that's fair because this is just an idea. It's likely your company's not worth very much on the open market, fair market value. Recognizes your sweat equity contribution. And as we talked about, it really represents what you guys have decided will be the future sweat that you're going to dedicate to this. Who should these go to? Founders and senior officers, not employees or outside investors. There's a lot of problems that we run into with people saying, I'm going to give it to all 8 people that are around. Even the person that says they can only give us 5 hours a week. And then, as so often life changes, you find yourself with shareholders on your cap table that you haven't spoken to in a year. They're very hard to get a hold of. Maybe they're holding up that financing Steve talked about, things like that. So be very protective of who owns this business from the outset, as I know it obviously will. The other thing that I run into problems with is somebody saying, well, I'm going to give this guy free shares because he said that he knows a bunch of rich people and they're all going to give me money. You have to be very careful with things like that because those relationships can often turn out in a manner that you didn't expect as well. And a lot of times we see founders get burned by those kind of promises of riches. Common other mistakes is not issuing enough founder shares. A lot of times we see somebody that it was incorporated and they issued themselves, okay, well, we get 50-50, so you get 50 shares and I get 50 shares. Well, okay, now here comes your new CTO and you're going to give them options for call it 2% of your company. Okay, now they have an option and they hold it up and it says, okay, I have an option for 2 shares. Well, aesthetically, that doesn't make somebody feel very good to have an option for 2 shares. And then you're going to get an investor and they're going to get 7.5 shares. Even for looks alone and to establish again a company that investors expect, you really want to be around 4 to 8 million founder shares, common shares at the outset. Consider future additions to your team. Oftentimes, your team is established through a process over the course of a year, months, a year, things like that. Investing founder shares. You heard us reference reverse vesting at the beginning. So let's put that let's present a tangible example. We have our 4 million shares outstanding. Steve and I have 2 million each because we're the co-founders, and we each say, with respect to our 2 million shares each, they reverse vest. We already own them, so they reverse vest over the course of 4 years. So let's say that 2 years later, and just call it a straight vesting schedule, not a cliff or things like that can be more complicated. We don't have time to talk about. So let's say in 2 years, I win the lottery. See you later, Steve. So Steve says, well, thankfully, I have this reverse vesting agreement, so the company enforces that contract against me, repurchases 1 million of my shares, half of my shares, because it's only been 2 of the 4 years, and at the price that I paid, and remember it was 1,000th of a cent, so they pay me my dollar or whatever it is, and then now Steve owns 2 million of 3 million shares, and And in a way that's an equitable outcome. I did contribute my 2 years of 4, but Steve's still contributing on a going forward basis, and he's fully invested in it. And why should I retain my full 2 million shares? So that's a kind of a tangible example of what I meant when I referenced that. Developing a financing plan. This is the thing you guys will struggle with the most, I think, and it gets back to what am I valuing my company as? What are my capital requirements? You need to determine your developmental milestones. What are they? Sometimes they're easy. I need to purchase this gigantic piece of hardware, this gigantic thing, this widget maker. Sometimes they're they're harder to predict. Sometimes they're intangible. Things like buying talent, things like that. By when will they be met, and how much funding is needed to is required to get there? You're going to have to present this to your investors and say, here's why it makes sense that I'm doing a financing for 500 grand, because 500 grand gets me to this inflection point. It will get me all the way there, and once we get this much traction, then we're going to raise $2 million at this larger valuation. But this story has to make sense and has to be compelling to investors. And things always take longer. There is always more salaries, more costs than you expect. So all things to be mindful of. We referenced sources of financing, and some of those were non-equity financing. IRAP, SHRED, we talked about. Other industry-specific grants. Quasi-government organizations, BCIC, BDC, Capital, great resource. They have a full, as a bank, full investor, full kind of venture wing that we see all the time in deals. They're very prolific, and they invest very founder-friendly money on relatively founder-friendly terms. So I would highly recommend engaging with them if you have the option. And so sources of equity, sources of financing, now equity. So again, we've established our company. We've created our very simple class of common shares. We've gotten a little bit of traction. Our idea is now starting to become a business. Now what next? Well, we're at our Christmas party, and we're talking to our friends, and we managed to convince them after a number of drinks that we're going to get about 200 grand from all of them. And that's what you'll so often see in the market is your kind of friends and family around. This is the people that know you investing in you. You don't have a business yet, likely. They're willing to make this investment in you, and they're going to come in on relatively friendly terms, so they're going to invest in that same common share class that we talked about. And they're going to get a great valuation on your company usually. It'll be a relatively thin amount of paper. It's not overly formal, things like that. None of the bells and whistles that we're going to talk about. Follow-on rounds from angels, venture capitalists, investment bankers. IPOs. That is certainly a rare occurrence, happening a little bit more. We just saw the Real Matters IPO. Shopify was a couple years ago. That's more rare. I think the typical life cycle for you guys, the successful companies in this market are likely going to be purchased by Canadian or international either competitors or strategics or large venture capital. That's just what we see in Vancouver. So what does this look like? Putting dollar figures on it. The founders are bootstrapping, and they're putting in as much money as they need to get this thing off the ground. Friends and family, 50, 150, 250, like I talked about, whatever you can scrounge from them. A lot of arm twisting involved. Angels, 250 to 500K. Again, these are just very loose guidelines. We've seen angel rounds for millions of dollars or smaller than this. VCs, they're usually investing enough money to really accelerate the growth of that company and get the returns that those VCs need to show to their investors. And then underwriters, strategic partners, things like that. So that kind of puts a little bit of a band on the different tiers that we've been talking about. I'm going to go into a little bit more detail about the venture capital program, just because I think this is a program that you all need to be intimately aware of. To take a step back, if you engage in an eligible activity, and let's call it the development of a novel piece of software, perhaps. Life sciences, you could be a medical device, doesn't matter. There's lots of examples. Clean tech, all sorts of things. If you are engaging in an eligible activity and you are going back to that BC company or that federal company, then the investment capital branch in BC has earmarked about $16.5 million in tax credits. They're refundable tax credits, and it represents 30% of your investment, up to $200,000. You can get $60,000 a year. And again, refundable tax credits, so that's a check. Like you're not applying this against, if you're an investor, you're not applying it against your income. Really powerful, because a lot of investors will say, okay, a lot of investors will say, well, I'm basically getting a 30% return off the bat. Like that's how investors think, right?
Yeah, so. $100 investment, you get a $30 refund at your tax time. It's big.
Yeah, so very popular, often drives the deal. They run out every year. The tax credit year is March to March. So we see a lot of activity in January, February, March, because everybody's really worried. They found this great angel investor that's going to give them a couple $100,000, but that person said, I really need the tax credit. And then they race off to see their lawyer, and everything goes in hyperspeed. There are obviously rules and restrictions around this program. You have to have under 100 employees. You have to have at least 75% of your wages paid in BC. Okay, putting on our government hat, why do they do this? Okay, paying their wages in BC, taxes. That goes down to 50% if you run certain export-focused businesses, 80% of your assets in BC, and you have to have received $25,000 in investment to qualify. So you have to have some sort of investment in. There's some sort of skin in the game already. You can't just set up a shell just to steal from the government, unfortunately. And then as important are the repayment obligations. So there's really kind of two baskets of repayment obligations. On the one hand, if the investor sells their shares within 5 years, then there's a repayment obligation, and that investor should make that repayment obligation. If they don't, then the branch will look to the company. So very important. Again, we're going, thinking about our investment paperwork, making sure that there's terms about that in there. And then there's things that will disqualify the company from being an eligible business. If I go from being a tech company to trying to compete with Ernest Ice Cream, then we're going to lose our eligibility, and then the company will have to repay the tax credits. There's lots of nuance to that. If you're selling the company at a huge loss, there's a forgiveness program, things like that, but that's the gist of it.
Right. I wonder if we're at our break slide. I was looking at the time here. I think what we may do is we'll just power through and then take questions at the end, if that's okay for you guys.
This is literally what we did last year.
Yeah.
The same sentence too. Well, we're behind, so we're just going to power through.
So, speeding things up a notch. Over to me, securities legislation. So every time you issue a share, securities rules apply. And there's basically two things to think about. The starting point is every time you issue a share, you're required to give a prospectus, or you're required to fall within a prospectus exemption. So all the text, once you file a prospectus, you're a public company, it's listed, all that sort of thing. So all the financing that companies do, whether they know it or they don't, falls or needs to fall within prospectus exemptions. So you'll hear about a number, let's just skip along here. You may hear about different exemptions. So every share you issue is going to likely fall within, there's about 30 exemptions. The common ones are, the friends and family, business associates, accredited investors. While you're a private issuer, there's a couple other ones. There's a $150,000 exemption. If a corporation that had a pre-existing purpose invests $150,000, that's an exemption. There's a startup crowdfunding exemption, offering memorandum exemption, employee, director, officer, and consultant exemption. So when you issue shares, you've got to make sure people fall within one of these categories. And let me just, get into them a little bit. So friends and family, I think a lot of entrepreneurs think this is a very big category of potential investors. The Securities Commission considers it a very small category of potential investors. Friends and family, friends, for example, this isn't Facebook friends. This is people that have known you for a period of years. People that know where the bathroom is in your house, people that have known you for a period of time to assess, your judgment, your trustworthiness, all these other things. So if you, looking at the downside, you sometimes hear about people that have issued shares to, they're friends, they're in this exemption. If any of these people complain to the Securities Commission after the fact, and I bought into this thing and I got hosed. It's the company and the directors are going to be responsible for having issued a security to this person without an exemption. And there's a couple of consequences. The first one is there's a rescission right on the part of the investor, so they have the right to get their money back. And the Securities Commission also issues fines and penalties and puts restrictions on people from participating in the capital markets in British Columbia for a period of time. So you want to stay well away from that. So the friends and family and business associates is a narrow exemption. When you're using it, you want to document who at the company knew them, how long they've known them, what the nature of the relationship is, a lot of other things. So when we get a subscription agreement for friends and family, we put in detail for all those things to be filled out, because that's your defense. If somebody complains after the fact, I got hosed by this thing, they said I was friends and family, but I only just knew them. You document it, because this is the one that Securities Commissions dive down the deepest on, because these are the people that they're trying to protect, right? The whole purpose of the Securities Commissions, not the whole, but one of the major purposes is protect, widows, orphans, and the unknowing public from, shady people that are trying to issue them stock. So they see it as a very narrow exemption. So use it very, very carefully and document when you're using it, so that you've got your defense when they ask you, how could you issue that, that stock to the person. Let's see. So that's more of the same. And yeah, more of the same. It's somebody known significant period of time and can assess your honesty and character and all those other things. Accredited investors, these are sort of your wealthy investors. There's a number of specific tests that are applicable. It's financial institutions, pension funds. The ones people typically deal with are the ones here, the last three. So somebody with $1 million in financial assets, somebody whose net income for the last 2 years exceeds $200,000, or combined with a spouse, $300,000, or individuals who have at least $5 million in net assets. So again, when you're issuing shares, if you're well advised, you always have a subscription agreement that has a schedule attached to it, and people tick the box as to which category they fall into. You're not allowed to be willfully blind when using these exemptions. You can't just give it to a guy that is down on his luck and just, he ticked the box. There's an expectation that you're doing a level of diligence, and you don't have a reason to believe it to be not the case. So make sure there's not an obligation to ask everybody to produce financial statements and show me this and show me your T4 or whatever it is. It's not that level, but you're expected to take reasonable steps when you're using this one. So this is probably what most people in start end up seeing is we're putting together a subscription agreement with accredited investors to make sure you've got all the categories on there and that you're doing some level of diligence in assessing the people. Private issuer exemption. So while you're a private issuer, you're under 50 shareholders, and you're issuing stock only pursuant to these exemptions. So it's directors, officers, family members, personal friends, current shareholders, and accredited investors. Once you issue to somebody that doesn't fall within this category, or once you issue pursuant to a different exemption, like a crowdfunding exemption or a offering memorandum exemption, or what have you, you can never go back and be a private issuer again. So you're from incorporation, you have a private issuer status while you use these exemptions till you hit 50 shareholders. If you go above 50, you lose it. And if you use one of the exemptions not listed here, you lose it. And the consequences of losing it, it's sort of like what I said before. It's not like you're automatically a public company, but you're no longer a private issuer, and it's more administrative rules. You've got to go to this. Anytime you do a financing from that point onward, you go to the Securities Commission, you make a filing. And just so you know, when you reach the stage when you're making filings of your securities issuances with the commissions, they start asking issuers about them. I've had a client that when they filed their first, we went over 50 shareholders. Here's our first report of exempt distribution. disclosure review. Can you please send us a list of every shareholder you have, every exemption you've ever issued under, supporting paperwork for all those people, and that sort of thing. So that's when you're glad that, okay, well, all our friends and family, yes, we had them fill out that paper. All of our accredited investors, yes, they filled out that certificate. You can be asked for it. You're normally not going to be on the Securities Commission's radar for that until you cross this, or until you lose your private issuer status and start making these filings. They can ask for it at any time, but that's sort of when they actually know you exist and that you're in the market. So, again, it's nice to be under 50 just so you don't typically have to deal with that sort of thing. Not that anybody would have anything to hide. And once you get over 50, this is when you're going to be very happy that you've done all your paperwork in the past and documented all of your securities transactions in a way that will stand scrutiny. So I've talked about private issuer. I've talked about loss of private issuer status. It's not the same as going public. It just means you can't rely on the exemptions and you need to make regulatory filings. 150,000 exemption. It can't be used by individuals. It can only be used by corporations. And it has to be used by corporations with a pre-existing purpose. And the purpose of that thing is they don't want a ton of people that don't have enough money to be accredited to pool their money together and all of a sudden have an exemption to issue to buy it. So this isn't for 15 people that have 10 grand to their name. This is for a corporation that had a pre-existing purpose and made this investment. Crowdfunding, this one gets some sort of notoriety, I guess. It's not an exemption. I don't think the lawyers think it's very good at all. It's a number of reasons. One, you can't raise that much dough with it. You need to put together an offering document. You lose your private issuer status because this isn't one of the private issuer exemptions. You're going to go over 50 shareholders. And you're going to, I've seen one where they raised 200 grand and they ended up with like 400 new shareholders. 400 shareholders. This is 400 people that you've got to round up and make sure you can get their stock back. There's 400 people that have to get notice of your AGM. When you're doing a special transaction, we need to go off and get all these people signed up to it. It's more trouble than it's worth, I think. So it's up to you. If that's the money you can get, that's the money you can get. But it's not going to be your friend in all likelihood. It's a lot better if you can raise that 250 grand from one or two people, put them in your shareholder agreement, manage it that way, than having this mass of people that you don't know that you're going to have to deal with down the road. Offering memorandum exemption. This is another one. If you use it, you lose your private issuer status. You put together an offering memorandum, you can go out and within BC, you can go up to as many investors as you want. Likely could go over 50 with this, so you lose your private issuer status, I guess you lose it anyway with using the exemption. People have rescission rights on an offering memorandum, so if there's you put together this disclosure document, if anything's wrong, they can have a right of rescission or a right of damages, and you need to collect risk acknowledgements. It's another one, if you can avoid it, avoid it. You lose your private issuer status. If you can just go to a few accredited investors and collect the money that you need to do your business, a lot better than going out with one of these things, ending up with a whole pile of shareholders, whole pile of people with rescission rights and rights of damages for misstatement and losing your private issuer status. So if you need to, you need to, but not my favorite. Director, officer, employees, another exemption that you can use. Consultant is a narrow definition. It's a written agreement, and it's providing services to you pursuant to a written agreement, bona fide, that sort of thing. So. Be aware it's a narrow thing. It's not sort of anybody under the sun. And over to Mr. Conlin.
Yeah, so I think we have about 12 minutes or so left for this portion, and we'll take questions. This is one of the more top of mind for you sections, which is raising money. Typically the proceeding would be that, as I discussed, you'll get an NDA with your potential investor. That way you have that protection once you start showing them your proprietary ideas, technology, things like that. You have a term sheet, a summary of the terms for their investment. Oftentimes when you're thinking of friends and family, angels plural, that term sheet will apply to a large number of people. So you'll say, I'm willing to give up this much of my company, 20%. I'm raising, call it $500,000 or $250,000, whatever you can, justify based on your valuation of the company, the story that you're telling, And that term sheet goes out to all of these investors and tells them what they're going to get for their money, certain rights and restrictions. Maybe there's a shareholders agreement. What does that say? And then based on the structure of your financing, whether it's subscribing for shares, whether those people are loaning you money, maybe that loan could be converted into shares at certain events, or a safe. A safe is something that you're probably hearing more and more, or if you start Googling these kind of concepts, a safe means simple agreement for future equity. The difference between these three is something that's on another slide, so we'll get into. An NDA, you can have mutual NDAs or one-way NDAs, depending on how that information is flowing. Typically with investors, you want a one-way NDA where they're keeping your information confidential. You want to make sure that you specify, and this goes back to making sure that you get good precedents from your lawyer. These are not. Nobody should be rewriting this thing for you. This should be something directly off the shelf, basically, that your lawyer can give you that has all of these protections built in, making sure that all information is confidential or only what is marked confidential, length of time, things like that. The length of time can also impact how certain areas of intellectual property are protected, things like moral rights. A term sheet. So again, as I discussed, this lays out the type of financing you're going to do. Maybe you're selling shares, maybe you're selling units. An example of a unit would be, for $1 you're going to have one share, and then you're going to have one warrant to purchase another share at $1 for 2 years. So that is a contractual right. So let's say that you use this financing, grow your business. In a year, the shares are now worth $2 a share. So now that warrant certainly becomes quite valuable then. Maybe it's convertible debt. Maybe you're borrowing money, and you say, okay, I'm gonna give you a promissory note. So this is debt. But if I was to raise $2 million, you agree that debt immediately converts into equity. So you're giving yourself a milestone that triggers that conversion. Good for you. Get that debt off the books. Get them onto the cap table. Valuation, pre and post money, non-diluted, fully diluted, partially. These are concepts that are all over the internet. There is a lot of dancing that investors and companies do with respect to how they're valuing. It's a lot more complicated than, okay, your company is worth $10 million pre-money, before I give you the money, and therefore it's X. There's a lot of variables that can go into that, which I'll illustrate in a minute. Use of proceeds, talking about what you're going to do with the money. Sometimes it's a very specific thing, buying that piece of equipment, etc. And then the investor's rights established by shareholders agreement, otherwise. So a subscription agreement, as Steve mentioned, there's a lot of legal requirements that go into that subscription agreement, but fundamentally it's setting out the terms that the investor is buying the securities, usually shares. If it's early, common shares. Representations and warranties about the company and those shares being purchased. So basically, those are promises that you're making or that the company is making to the investor, saying things like, I'm not being sued right now. Saying things like, I own all of the intellectual property I need to grow this business. Getting back to making sure that we had all that IP assigned so we can make promises like that now. Things like indemnification if the investor suffers a loss because of a lie we told in this document, they can be made whole. Convertible debt, like I talked about, it's a debt investment that can be converted on future financing. Repayment terms, it's a repayment obligation at the end of the term, so this is still debt. And it could be evidenced by a more formal structure. It could be a secured debt. There could be a number of lenders, and there's a separate agreement that governs how they all interact with each other. One can't call the loan without the others approving it, things like that. And then the key thing for you guys as founders is debt is not eligible for those EBC tax credits I talked about. So you can't get that 30% refundable tax credit when you have debt. And obviously it would have all the other markers of debt, interest, and things like that. Safe, simple agreement for future equity. That is not debt, doesn't show up on your financial statements as debt. It will always turn into shares, whether it's by virtue of that triggering financing in the future we talked about, $2 million, whether it's by virtue of some sort of maturity date conversion. You and your investor agree, well, no matter what, in 2 years on this date, it's turning into shares at this valuation. And the key is this is eligible for EBC tax credits. So a lot of people are finding this to be very valuable because it marries really two founder-friendly things. On the one hand, you don't have to value your company at this stage because the safe says that it will convert at the valuation that future investors are going to pay for for shares. Now there's still a reward for investing at this risk profile because the holder of the safe will maybe convert at a discount to what those people are paying. Because you, of course, have to reward that investor. They're investing much earlier than later Angel did. Or there might be a cap on the company valuation. So you might say, okay, well, this safe is going to convert, but it can only convert up to a company value of $5 million. That's an investor protecting themselves. If you were to go find somebody that drank all of your Kool-Aid and is willing to invest in you at $100 million, then all of a sudden this little $20,000 safe gets you nothing, right? So there's a cap on the investment, on the value, things like that. And the key here is that it does get EBC tax credits, but the EBC tax credits you get when it converts into shares, not when you sell the safe. So a lot of founders find this really valuable. Tax credits plus punting the issue of valuing your company at that early stage. Stock options. We've kind of talked about it a couple times. What are stock options? Right to purchase shares at a predetermined price used to incent team building. Typically what we're seeing is somewhere between 10 and 30, 10 to 20% of the issued capital in a stock option pool governed by a stock option plan that contains terms such as what happens if you sell the company and there's outstanding options like Steve talked about. And the key is when you're issuing or granting stock options to your employees, granting them with a strike price equal to fair market value at that time. There's a key exception here, and that is that there's a regime under the Income Tax Act that says that in certain situations with employees, you can give them a right to purchase shares, and when they exercise that share, they have a preferable tax treatment that will result in capital gains treatment on their shares. So what do I mean by that? Because I think this is an important example because we deal with it with founders all the time, so I'll spend a minute talking about it. So let's say that you start your company and you and Steve and I have 50-50 ownership, and we've issued ourselves shares at a thousandth of a penny. And in 8 months, or in 6 months, we find some of our friends, they give us an investment for shares at 25 cents. So right there's a new fair market value for our shares, 25 cents. But 3 months after that, we realized that other employee we had has really been going above and beyond the call of duty. And they're such a huge part of our success that they should be an owner of this business. They deserved to be a founder. One of the things we're seeing is using this regime to say, okay, we're going to give you an option to buy what would have been the equivalent of 20% of the company. And we know that option is below fair market value because we're going to use a strike price of a thousandth of a cent or whatever. Now, if the employee immediately exercises that and holds those shares for 2 years, then the difference between the fair market value, 25 cents, and the strike price, thousandth of a cent, that would have otherwise been an employment benefit and therefore taxed under employment levels of tax, is basically given capital gains treatment. And the employee doesn't have to pay tax right away. As long as they hold it for 2 years, then when the company eventually sells, it'll be like, just kind of cutting to the crap, putting my founder hat on, it'll be like they were a founder from a taxation perspective, and tax often drives a lot of these deals. Those are kind of a couple of the tools that we as lawyers give to our clients when they say, when they encounter problems like this, common things where they say, I really want to do X, Y, or Z. There's often a way to get there, but it requires getting advice from your lawyers and accountants. Okay, getting into the details a bit more, stock options. This is typically the bands we're usually seeing within a plan. Again, this is within the stock option plan, so within the 10%. These are kind of some of the percentages. Making sure they vest over a couple of years. So when we talked about reverse vesting, you already own the shares. Now we're vesting the options. So if I was to give Steve 1,000 options or 1,000,000 options, maybe 10,000 vest over each month or something. So it grows as you go, right?
Yeah, options are to incentivize the future performance instead of the reward for the past, typically. So you want them to come out in stages to keep the person motivated to continue.
Yeah. So So I'll just wrap up. So we have about 15 minutes left. So I'll wrap up in the next 5 minutes, and then we'll have 10 minutes for questions. So this is an illustrative progression of a company, and certainly, this could be one way it goes, but there's thousands of ways that a company could go. But let's say that there's 3 founders. So each of the 3 of us, we have our 2 million shares each, and again, like I said, we had anomaly priced shares. So the founders own 100% of this company. We convince our friends and family to invest a total of 100 grand, and same 25 cents that I mentioned. So that gives them 400,000 shares. Well, now there's 6.4 million shares in the company. Because they invested 100 grand, the post-money value is 1.6 million, and the investors still own a very large amount of that, right? They own about 94% of the company after that financing. At that time, they used that 100 grand to start hiring people, and they went to their lawyer and they said, a lot of these employees are asking for options so that they might be an owner one day. So you established an option pool of 1.5 million shares. You'll notice that I still reference the founder's ownership on a non-diluted basis. Non-diluted means that it doesn't include the dilution that plan would include. So the founders still own about 94% of the company. Fast forward to your angel investment round, you were able to convince a number of Vancouver angels to give you just over $400,000 at 35 cents. Now again, these angels, you had a successful negotiation and you were able to convince them not to include your option plan in the valuation. So when they said they're going to give you that money, they said 35 cents. They used the valuation on the basis that there was 7.6 million shares. Now fast forward to your Series A. So a very sophisticated venture capital firm came in and they said, okay, we're going to invest in you for $1.5 million and 50 cents, but we are going to do that on a fully diluted basis, which means that we are going to, we're giving you 1.5 million, and but we're going to, when we think of the share price, we include the option pool. So all of a sudden you say, okay, well, now it's as if all of those shares were, all of those options were issued shares. So now the founder's interest has gone down to 47.6%. One of the rubs here is that a VC will often say, you're really going to need to do a lot of hiring with our money, and so you're going to need to increase your pool. Oh, and by the way, that increase we're talking about, put it on the pre-money side to dilute yourselves. So even though we're asking for it, you're going to bear the dilution of that. And then to round it out, you convince another VC to do a Series B at $1 for $5 million. And so now what you see is the same option pool. The founders are down to 34% of the company. They've received over $7 million in investment. They have a stock option pool that's equal to about 12-13% of the issued and outstanding shares, and this is a bit of a snapshot of what a life cycle could look like. It touches on, but does not. We don't have enough time to go into all of the nuance, but it touches on issues related to valuation, issues related to what is included in when you're saying, okay, my company's worth X, but on a per share basis, what do I have to include to come out with a number? And what does that mean for me as a founder when you're talking about giving away pieces of the pie? So hopefully that was a short but enlightening example. We only have 10 minutes left, so I will just I will touch on just that licensing agreements, sales services agreements, your commercial agreements. My only takeaway here is that this is really where we start to depart a little bit from the template model of the provision of the document by your lawyer. You're really going to need legal advice for these, making sure that you're protected in this regard. And if you need help, let us know. Now we'll take questions.
Okay, Simon.
Okay, I think they're going to be going around with a microphone because this is recorded. So.
Hi.
Hi.
Thanks for your thorough presentation. With regards to funding rounds, and the legal regime you mentioned for options. Does the valuation count at the, let's say, quote, opening or the closing of the round?
Yeah, so it's a great question. So what you've talked about is kind of when people discuss pre and post money valuation, right? So there's a pre-money valuation that will apply, and that's when I reference, okay, on a pre-money valuation, your company is worth, let's call it 10 million bucks. Now, if you include things like options, things like those warrants, maybe you issued units to some of your investors and they had a warrant or something. Maybe there was some convertible debt, all sorts of stuff. The pre-money value is before your investors invest. The post-money is, let's say that it was 10 million, you're going to give me $1 million, it's 11 million bucks. I think that's kind of the obvious answer, but is there a follow-on that you?
I guess I meant in terms of like time sequencing, right? So where it takes a long time to close a round because you're have a laggard investor or something like this.
Yeah. So again, good question. It's the establishment of that pre-money value, which to wrap it all up will go on your term sheet that will go to your potential investors. That's locked in stone. Now, if you have some sort of inflection point where, I don't know, I just did one for a medical device, so you get FDA approval or something, then maybe you can go back and say, deal's off the table, new deal on the table, guys, because now we have all this leverage because we've got all this traction. But typically, no matter what the lag is, and I've done deals where it took them a year to close, and it was very painful and expensive, it was the same valuation. I don't know, Steve's probably got good insights as well.
Yeah. What I was just going to say is, just so we're using some terminology on here, the distinction between the pre-money valuation and the post-money on this slide, for example. So you look at the price of $1 per share. All the shares issued prior to that multiplied by $1 is your pre-money, and then you add the $5 million that they're putting in as the post-money. So that's part of it. But I think in terms of the option plans, there's a negotiation point as to whether that gets jammed into the pre-money or not. And it's, normally I would say investors insist on it going into the pre-money, but it's a negotiable point. Question at the front? Oh, it was with the guy with the microphone.
Yeah, hi. I had a question about employees kind of avoiding taxable events like you mentioned with the founders. In the States, they have an 83B where you can essentially convert options into restricted stock immediately within 30 days, as long as you do within 30 days, and then you're taxed at that event. But you can hold that, and so that when you decide to exercise later on, you're not, you don't have a huge tax burden.
Yeah.
Is there something in Canada that's equivalent to that 83B for early employees?
Yeah, so one of the things when I was talking about why you want to be, a Canadian-controlled private company rather than a Delaware company or whatever, one of the benefits for your Canadian employees is when if they've issued options, their tax event will not be when they exercise their options, but it'll be when they sell the stock. Whereas if they were holding your Canadian employees were holding shares in an American company, they'd pay tax at the time they exercised, which is difficult because one, you're not going to have the cash to pay your tax bill, and two, you don't know what the future result will be. So it's a really nice thing to be able to delay your taxable event until you sell, so you'll have the cash and you actually have certainty of value. So Canadian-controlled private corporation is another reason why you want to be one.
So an ideal situation, you've got 3 people all equally contributing as founders. So you split the equity 3 ways. Is my voice a bit loud?
Yep.
But sometimes that doesn't happen. Do you guys have kind of like a template for splitting equity that recognizes, this guy knows everybody, he can walk in and give us a huge customer list right out of the gates, this other guy, something different, or is throwing in a bunch of money themselves? How do you do that in a really fair and sort of objective way?
So one question, are you talking about
splitting equity?
It's already been granted and now you're wanting to reallocate? Or
I think they're just starting.
No, you're just starting.
Oh,
You're
okay.
just incorporating. You got 3 different people with very different propositions of value. Yeah, is there just kind of like an easy template, an objective model for splitting equity between founders?
Yeah, it's unfortunately it's not a legal question, right? It's a breakdown that will keep everybody engaged to the level you need them to be engaged. So, you're not going to get now. I can come up with metrics that say this is usually what the technology guy gets, or this is usually what the business guy gets. But largely, it's going to be a function of what the 5 of you in a room have decided. Unsatisfying answer, certainly, but
It depends on the
that-
personalities.
Yeah.
Some people, the strong personalities pushing for things, and it gets cut up a lot of different ways. But probably everybody needs to be their own best advocate there.
How about the other interpretation of the question?
The other,
Oh, if it's already been allocated, well, that's when you're screwed, right? Once you give out stock, unless you've come up with a way to bring it back in, a reverse vesting agreement, things like that, once it's out the door, it's out the door. So that's why when you put it out, make sure you've thought in advance about how to get it back if you need to reallocate it. And the reverse vesting agreements are great for that. If you don't perform, stock gets bought back by the company. You want to leave, fine, you lose your stock. Just further, well, I guess it depends. If you're still at a penny valuation, is fine. But if you're not, and you've been issuing stock at 25 cents, you're really going to piss off the people that, yeah.
Yeah, life's still easy if your company's worthless. But